Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother, cause he was from that side. And why? He chose this son, cause this one had pride. And instead of the narrow road, he chose the one that's why. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
We are in the information age on Do You Know Your Value page. It's the content creator with force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. As we proceed to give you what you need, this is part 2, creditors and their bonds. Continuing where we left off. We left off on appearance bond. And we will begin now. Appearance bond. This is a bond that assures you will appear in a court proceeding. It is not a catch-all bond that covers everything that will come up in the case. To get the appearance bond, you have to give your word bond that you will appear to finish settling the accountant. It is issued by the hearing officer if it is requested and if there is no controversy. If you are honorable enough to not to start arguing with the hearing officer or the complainant or the prosecuting attorney, you could get this bond. There must be no controversy. The fact is established by your voluntary act of accepting the charging instrument for value and returning it. In doing so, you are exchanging your exemption for the discharge of the charges. You are bonding your pledge to appear and settle. If it were not voluntary, that would be bondage. You must tell the hearing officer that you are not disputing any of the facts. Dispute, a conflict or controversy, an assertion of a right, claim, or demand on one side met by contrary claims or allegations on the other. The subject of litigation, the matter for which suit is brought, and upon which issue is joined, and in relation to which jurors are called and witnesses examined. When you're in a dispute, you join the issue and confirm the existence of what was just an idea, making it materialize and give subject matter that can be tested by a jury or witnesses. Once you ask for the bond, it is yours. If you ask for it again, it will appear that you do not know that you already have it, and the hearing officer will proceed as though he is talking to the debtor straw man. A debtor straw man does not automatically get an appearance bond. It may be required to pay for a bail bond. An appearance bond with conditions incorporates a cost to you. If you have requested the appearance bond at no cost to you, there will be no conditions to the release. If you do not ask for it that way, there may be conditions like drug testing, required meetings with court officers, and required daily and weekly phone calls. Those are at a cost to you as they take your time and your property. If you don't appear and settle the accountant, you will be in dishonor of your word, and the appearance bond will be revoked. They will not tell you it has been revoked. Your dishonor will then be used to carry out the presumption that you are representing the straw man in a fiduciary capacity and that you are in breach of your fiduciary duty. That is not allowed in equity. Then the debt of the straw man will be put on you. If there's not enough property held in the name of the straw man to cover the dishonor, or if you as trustee refuse to turn over the trust property to settle the debt, they will take your body as surety for the debt. It is the trustee's body being taken. You volunteered to be the trustee. Charging order, statutorily created means for a creditor of a judgment debtor who is a partner of others to reach the debtor's beneficial interest in the partnership without risking dissolution of the partnership. Uniform Partnership Act, subsection 28. The purpose of the court case is for the judge to test the facts of an accounting. He is the auditor in a possible dispute between a creditor and a debtor. The creditor always wins. It is a matter of how much the debtor will pay that is being determined in the court case. Audit, systematic inspection of accounting records involving analysis, tests, and confirmations. The hearing and investigation had before an auditor, a formal or official examination and authentication of accounts with witnesses, vouchers, etc. Audit, he hears, a hearing from audio to hear. Auditor, an officer of the court assigned to state the items of debit and credit between the parties in a suit where accounts are in question and exhibit the balance. Under rules of civil procedure in many states, the term master is used to describe those persons formerly known as auditors. Magistrate, a master, magia, sorcery from Greek magia, the theology of magicians. Vouch, to give personal assurance or serve as a guarantee. Voucher, a receipt, acquittance, or release, which may serve as evidence of payment or discharge of a debt or to certify the correctness of accounts. Surety bond. The surety bond is used to subrogate liability from one party to another. It is similar to an indemnity bond. You can issue a surety bond to relieve someone who is in dishonor of potential financial damage. You can indemnify an honorable party who may have made a mistake by volunteering to be his surety. This is often the case with a judge. If you do this, you are moving into a creditor position because you are taking responsibility for the actions of another. 3 parties are requested. 1, the one who is volunteering to be the surety. 2, the debtor. And 3, the creditor. There can be more than one creditor and more than one debtor. Creditor status can change during the case. When you become the creditor, someone has to be the debtor. The prosecuting attorney signed the complaint. There's no bond in the case file, and there's no signed security agreement. He's going to be the debtor. If he acts honorably and tells the judge he wants to settle or have the case dismissed, he stays in honor. You may have to authorize him to sign a check to settle the accountant. If he acts in dishonor, he's the one who will be left holding the bag. You can bond the parties and or bond the case. Suretyship, the relationship among 3 parties whereby one person guarantees payment of debt owed to a creditor, or acts as a co-debtor. Generally speaking, the relation which exists where one person has undertaken an obligation and another person is also under an obligation or other duty to the obliged, who is entitled to but one performance, and as between the two who are bound, one rather than the other should perform. Suretyship bond, a contractual agreement created by your mother's signature on the application for the birth certificate between the surety, the principal, and the obligee, whereby the surety agrees to protect the obligee if the principal defaults in performing the principal's contractual obligations, discharging debt, or in any way dishonors the plaintiff. The bond is the instrument which binds the surety. The surety bond is delivered to the one who dishonored you. It is wise to have evidence of the dishonor before you issue a surety bond. Satisfactory evidence could be a certificate from a notary after the administrative process has been completed to assure there really is dishonor. You might just think you were dishonored. If you are in dishonor yourself and have not corrected the mistake, you are not in a position to be claiming you have been dishonored. This is a very narrow window. You must always approach equity with clean hands. The surety bond is also delivered to the bonding company if the one in dishonor is a public officer with a bond. It is also delivered to the clerk of court. If there's a court case in process, always get a certified copy of the surety bond from the clerk after it is filed. Number 6 will be the case bond. This bond is in the nature of a replevin bond. A replevin bond was formerly used in common law when there was a dispute and one party chose to file a claim in court against another party in possession of property in dispute. The moving party was required to bond his charge before he could get temporary possession of the subject property. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff who seized the subject property from the defendant in possession. The other part was to guarantee the defendant would be reimbursed at least for the value of the seized property if it were not returned to him in the event he won the case. In equity, all charges need to be bounded. You have heard, put your money where your mouth is. That is what is happening when charges are brought in court and the moving party bonds the case. This policy assures the defendant will not be damaged by an unsupported complaint. Charges are rarely bonded in modern court procedures until after the case is decided. By that time, the defendant is almost always in dishonor, so the prosecuting attorney can use the defendant's dishonor to bond the case. It is really the defendant's representative that is bonding the case. Again, it is the man's credit that gives life to the bond. If the defendant is in dishonor of what its representative said or did not say or did not do. It is the trustee's credit that is used to satisfy the debt, discharge the bond. You can voluntarily bond the case if there is no bond already in the clerk's file. Be sure to get a certified copy of the docket sheet as evidence there is no bond in the case before you issue your bond. When you bond the case, you are the creditor and creditors win. If you bond the case, become the creditor, and then dishonor the judge, the attorneys, or the process in any way, you will lose your position as a creditor and go back to representing the defendant. All the dishonors are pinned on the defendant, even if you are the one who went into dishonor through your words or your actions. The defendant cannot talk or act. It all comes from you. If you bond the case and underwrite all the obligations, loss, cost of the honorable citizens of the state of whatever, that would include the attorney as long as he is honorable. If he is not, he refuses the indemnification and volunteers to have his dishonor give the commercial energy to the settlement. It is up to him. The judge will go along with what he requests. Usually, the attorney will tell the judge that the plaintiff moves for dismissal. Number 7, performance bond. Performance bonds guarantee that parties to a contract will not be damaged by the conduct or lack of conduct of an officer. This could include an executor, trustee, officer of a court, officer of a corporation, guardian, etc. Wherever there is a fiduciary duty, there may be a need for a performance bond. An oath is a performance bond in common law. In the modern states, an integrated court system, bonds are backed by insurance companies. They are actually insurance policies. Performance bond, type of contract bond which protects against loss due to the inability or refusal of a contractor to perform his contract. Such are normally required on public construction projects. Official bond, a bond given by a public officer, conditioned that he shall well and faithfully perform all the duties of the officer. That he shall well and faithfully perform all the duties of the office. Contractor, one who is in pursuit of independent business, undertake to perform a job or piece of work, retaining in himself control of means, method, and manner of accomplishing the desired result. Construction, interpretation of statute, regulation, court decision, or other legal authority. The process or the art of determining the sense, real meaning, or proper explanation of obscure, complex, or ambiguous terms or provision in a statute, written instrument, or oral agreement, or the application of such subject to the case in question by reasoning and light derived from extraneous connected circumstances or actions or writings bearing upon the same or connected matter, or by seeking and applying the probably aim or purpose of the provision, drawing conclusions respecting subjects that lie beyond the direct expression of the term. And the next term we're coming across is refusal. And right here we're going to be stopping on page 8. I don't want to make this too long. I want to make them short, concise, but definitely make sure that you're looking up words. Don't go past words that you don't understand or you're not familiar with. That's the best way to understand this information. And this information is very valuable. This information is very valuable, people. You really want to get this. Well, peace and blessings. And I will talk with you guys later.